Well, and another question that I had on this, and I wanted to ask you, the SLAPP guru, Jeff, on motions for summary judgment. The rule is that the trial court has to rule on any evidentiary objections before the matter is submitted at the oral argument. And I didn't know what the rule is on anti-SLAPP practice. If there's been evidentiary objections raised, what happens what happens to those objections if the court doesn't actually incorporate any rulings on them in the tentative or in the ultimate decision or at oral argument?
Yeah, that's a great question. And by the way, what if you ask for a ruling on those objections at the hearing and there's no court reporter? Like in LA and Orange County, there's no court reporter. I don't think a specific case is actually in the anti-SLAPP arena evaluated like they have in the MSJ context, that you have to make a request for a ruling on evidentiary objections or it's deemed waived. So I have therefore in my practice just assumed that if you do not make a request at the hearing for a ruling, it will be deemed waived. And I just had a hearing last week where a judge took the position, well, I didn't consider any of the evidence in connection with my ruling, so I'm not going to rule on your objections. That left me feeling unsettled, but I made my request for a ruling anyway.
Good. Well, so yeah, I think you're probably right that if there's not been any indication in the tentative ruling offered by the trial court on your anti-SLAPP motion that the court has ruled one way or the other on your evidentiary objections, I think you ought to make a request at the oral argument hearing, because otherwise, yeah, you're probably right. The Court of Appeal would just assume that it's waived, treat it the same way it does under the MSJ statute.